USCIS just issued a memo that is changing how officers decide green card cases. And if you have a pending I-485 or you're planning to file one, you need to understand what this means for you right now. On May 21, 2026, USCIS released Policy Memorandum PM 602-0199 titled Adjustment of Status is a Matter of Discretion and Administrative Grace. That is a significant statement. But here is the truth. This memo does not end adjustment of status, and it does not mean your case will automatically be denied. What it does mean is that preparation matters more than ever before. In this video, we are going to break down what this memo says, why it matters, what we still do not know, and what you should do right now to protect your case. We are a Longue law firm, and we are actively monitoring this issue for our clients. Stay with us through this entire video. Every part matters. Before we get into the memo, let's make sure we are on the same page about what adjustment of status actually is. Adjustment of status, also called AOS, is the process that allows certain people already inside the United States to apply for a green card without leaving the country. Instead of attending a visa interview abroad, applicants can apply for permanent residence from inside the United States. Some people apply through marriage to a U.S. citizen. Others apply through family petitions, employment sponsorship, or humanitarian programs. For many families, adjustment of status is more than a legal process. It is the difference between staying together in the United States and facing uncertainty abroad. And that is exactly why this memo matters. So, what does this memo actually say? The memo reminds USCIS officers that adjustment of status is a discretionary benefit, not an automatic entitlement. That means even if an applicant technically qualifies for a green card, USCIS officers are still allowed to decide whether approval should be granted. The memo instructs officers to review the totality of the circumstances. In other words, your immigration history, your conduct, your background, and your positive factors may all play a role in the final decision. The memo also refers to adjustment of status as an extraordinary relief. That language is important. Technically, adjustment of status has always involved discretion. But what makes this memo different is the way USCIS is emphasizing that discretion publicly and formally. The concern many attorneys have is that officers may now feel encouraged to scrutinize cases more aggressively. Cases that once seemed straightforward may now face deeper review. This does not mean applicants should panic, and it does not mean cases should be withdrawn. But it does mean applicants need stronger preparation than before. Your case now needs to do more than prove eligibility. It needs to tell a complete and persuasive story. This memo is still very new, and right now there are important questions we do not yet have answers to. Will all USCIS field offices apply the memo the same way? Will marriage-based and employment-based cases be treated differently? Will courts step in if discretion is applied too aggressively?
The memo suggests officers may pay closer attention to certain negative factors in adjustment cases. These can include prior immigration violations, overstays, unauthorized employment, status violations, fraud or misrepresentation, and criminal history. USCIS may also examine whether a person's actions after entering the United States matched the purpose of their visa. For example, entering on a tourist visa and immediately pursuing permanent residence could raise questions about intent. It is important to understand this clearly. Having a negative factor does not automatically mean denial, but it does mean those issues should be addressed carefully and strategically. The good news is that USCIS officers are also expected to weigh positive factors. These are sometimes called positive equities. Examples include family ties in the United States, stable employment, paying taxes, community involvement, church participation, and hardship to family members if the case is denied. Let's clear up some of the fear circulating online. This memo does not abolish adjustment of status. It does not mean all pending I-485 applications will be denied. It does not eliminate marriage-based or employment-based green cards. And USCIS still has to follow federal immigration law. If you have a pending adjustment case, do not withdraw it based on headlines alone. Instead, review your case carefully with an immigration attorney. Look at your full immigration history: prior entries, prior denials, overstays, visa applications, unauthorized employment, criminal history, and any inconsistencies in prior filings. Applicants should also begin gathering stronger evidence of positive factors, including tax returns, employment records, family evidence, community involvement, and hardship documentation. Preparation matters now more than ever.
Applicants should also be prepared for possible RFEs and NOIDs. An RFE is a request for evidence. A NOID is a notice of intent to deny. Under this memo, officers may issue more requests when evaluating discretionary concerns, and these responses should never be handled casually. International travel is another major issue. If you have a pending I-485, consult an attorney before leaving the United States. Travel without proper authorization can create serious immigration consequences. The most important thing to understand is this. This memo does not end the path to a green card, but it does increase the importance of preparation, documentation, and legal strategy. At Alonji Law Firm, we are actively monitoring how USCIS applies this memo in real cases. We are helping clients strengthen filings, prepare discretionary evidence, respond to RFEs and NOIDs, and evaluate the safest legal path forward. If you have a pending I-485, if you are planning to file, or if you have concerns about your immigration history, we encourage you to schedule a consultation. And if this video helped you, make sure to like, comment, and subscribe for future immigration updates.